Welcome to the Aging Boomers. I'm your host, Frank Sampson, and on this show we discuss many of the issues facing boomers, their parents, and what, of course, we know is an aging population today. So thanks so much for joining us. Thanks for all your support on iTunes and on agingboomers.com, and many of you have downloaded the free app on your iPhone or Android phone, and if you haven't, please do, and that way you get updated on all the future podcasts and great interviews that we have with so many experts, and we have another one today, which I'm going to introduce in a minute, but just want to let you know our show is sponsored today by ElderCareResourcesUSA.com. Information for an aging world. You can enjoy informative articles, watch videos, download helpful guides, and learn from nationally recognized experts, and connect, of course, with key local providers. You can go to ElderCareResourcesUSA.com. If you're out in the West Coast in California, you could go to the local sites at ECRBayArea.com, ECRSacramento.com, and, of course, in Southern California at ECRLosAngeles.com. So check it out. A lot of great information on there, and now I want to get into our show, talk to our guest, introduce our guest. His name is Jamie Watson. Jamie graduated with a Bachelor of Arts in International Business, cum laude, from Linfield College in Oregon. His collegiate career is highlighted with studies abroad in Austria and a national finalist for the Fulbright Scholarship, culminated by graduating with distinction from McGeorge School of Law up here in Northern California. Jamie has made a name for himself at Gaw Van Male, being a key component in the wealth preservation and elder law areas of practice, speaking often in seminars and private lectures regarding estate planning, Medi-Cal planning, veterans benefits, and special needs trusts. Jamie, thrilled to have you on the Aging Boomers. Thanks for joining us.
Well, thanks for having me. It's great to be here.
Yeah, a lot of good information to discuss today, and I'm going to just start it out so people, because there's a lot of terms that are used that people I'm sure have heard of but don't quite understand what it means. Whether it's and one of them's estate planning. Okay, estate planning, you hear that term all the time. And could you explain just what an estate plan is in simple terms?
Sure, yeah. A lot of folks, when they come into my office, don't really realize that the state of California, and many states for that matter, depending where your listeners reside, if they don't do estate planning with an attorney, or certainly there's lots of websites where you can go online and download estate planning documents and things like this, but a lot of folks do not realize that the state of California, if you don't have an estate plan, has an estate plan for you. So if you don't write down your wishes on how assets are to be managed during your lifetime, or for that matter, when you pass away, the state of California dictates through the probate code where your assets end up going. And a lot of times folks would find those provisions in the probate code counter to really what they want. So when folks come and see me and ask about doing estate planning, really what I try to explain to them is during your lifetime, putting together an estate plan, and it kind of encompasses multiple things, and we'll talk about that, but putting together a estate plan is a system of lifetime management of the assets in the event that, for example, I become incapacitated. Who do I want to manage those assets? How do I want those assets managed? Who has the power to sell assets? Who has the power to buy assets? And really, what I think most people understand is a designation of your wishes when you pass away. How do I want those assets to go to my loved ones, or my children, my spouse, under what terms do I want those assets to pass to those individuals?
Well, that's a great way to put it. So what makes up the actual estate plan? What are the different parts of it?
Yeah, so for most people, 95% of my clients that walk in here we talk about a living trust, and really that's kind of the centerpiece of an estate plan. And a lot of folks have heard the term revocable living trust or living trust, and really that's kind of the centerpiece of most people's estate planning documents. And really the living trust is, again, it's kind of the designation of the wishes on how assets are to be managed during my lifetime, and also where those assets pass upon my death. And so kind of surrounding the living trust, if that's the centerpiece, are several other kind of key documents. Really, to me, one of the most critical is a durable power of attorney for finance, and we'll get into that a little bit. And that's a designation of how the assets outside of the trust. So, for example, my home goes inside of the trust, physically moving the title into the trust. My bank accounts physically move inside of the trust. Well, certain assets like IRAs, 401ks, 403bs, you don't physically put inside of a trust. And so what you need in that circumstance is a well-drafted power of attorney to be able to deal with those assets in the event that I'm unable to, I'm out of the country, I'm incapacitated, or I just am not able to deal with those assets outside of the trust. So durable power of attorney for finance, certainly a really important document, is also an advanced health care directive, designation of wishes in the event that I can't make medical decisions for myself. So that's another component of the estate plan. Deeds to physically move the properties that you have. Most folks that walk in, their main asset is their primary residence. So you can have a great trust, and it can be the best drafted trust in the world, but if you don't fund the trust, meaning you move the assets into the trust, it doesn't do anything for you. So what I find is a lot of folks come in and they'll have done a living trust, and when they go to refinance their house, the bank says, well, you need to take the house out of the trust so we can refinance it, and they never put the house back into the trust. And so it can create a lot of issues, and the folks thought they had avoided probate maybe on the death of one of their spouses or the death of the second individual, if a married couple, and they come to realize that the house was taken out of the trust and it was never put back in. So you have deeds that are a component of the estate plan. And also, a lot of times we do HIPAA releases, so Health and Privacy Act releases, so individuals, designated individuals, can have access to medical records, which is extremely important, when you're dealing with medical situations for especially aging clients. Mm-hmm. And then also coordination of beneficiary designations. I kind of talked about assets outside of the trust, so 401ks, 403bs, IRAs, making sure that those assets are, and how they pass to your loved ones, are coordinated with the terms of the trust. So oftentimes we coordinate the beneficiary designations with the trust as well.
Okay. So somebody listening to, and I know I want to preface that, you're going to probably be talking about laws as it relates to California, may be different in different
Sure.
states, right? But somebody who's listening to the show, let's say that they already have a will, okay?
Sure.
But they don't have a trust. So somebody listening to this says, well, why? I have a will, why? And it says in there where everything should go and who's going to get my jewelry and all that sort of stuff. Why would they need a trust, and why, and maybe they don't? I mean, can you explain that?
Sure, yeah. Most folks, what they don't realize, when we talk about a will and when it is effective, a will, in the term that folks use in the legal community, is will speaks at death, meaning that the provisions of that will only become effective the moment I pass away. So oftentimes for individuals, you're looking for assistance, especially, and I've seen many clients that have loved ones that are starting to decline mentally with the onset of maybe dementia, Alzheimer's. It's becoming more and more frequent that I see clients like that. So oftentimes a will is not going to dictate the management of those assets during my lifetime. It only talks about what happens to those assets at death. So that's one reason. It's a system of management for the living trust, a system of management for assets during your lifetime. If you're starting to have decline and mentally and you're unable to manage your assets. The other major reason that people use a trust over a will is the avoidance of probate. So when I have a will and it speaks at death, like I said, you have to submit that will to the probate court, which is a public proceeding. So a lot of folks like the privacy of the living trust. They don't want their assets in the public sphere, which having a probate is the public sphere. And so a lot of folks, when they submit the will to probate, don't realize that that's a long process, 6 months, year-long process, depending on where you're located throughout the United States and the backlog of the courts. Here in California, it's the courts are particularly busy. And so when they submit the will to probate, they're often waiting 6 months, or the heirs are often waiting 6 months to a year to complete the process of administering the estate. Whereas a living trust, you don't need to go to probate. You can come into the attorney's office who drafted it, and they can administer the trust in the office in a private setting. So most folks like the privacy aspect of the living trust as opposed to a will, and a lot of folks like the efficiency of the trust administration a lot more.
Got it. All right, that's good explanation. So I do want to get into what's called powers of attorney. All right, and
Sure.
You mentioned that before, durable power of attorney. In all due respect to your profession, I think it's a lousy name, and I only say that, because I think it scares people away. They think a power of attorney is something that's going to cost them a ton of money, and what do I need to do that? That's my only reason. But
Sure.
It's really pretty simple. But you got to be careful, make sure it's written in the proper way. So you want to discuss what a power of attorney is, and why, if you agree with me, why practically everybody should have one, at least if you're an adult. It doesn't have to be a senior adult, just even a child. I mean, I think my kids have have a power of attorney for themselves. So
Sure.
You never know. So why don't you explain that?
Sure, yeah. Well, to me, the power of attorney, if you do nothing else, especially if you're an aging individual and you're in a situation where perhaps maybe your spouse is predeceased you, I can't stress highly enough that it's just such an important document to have, regardless of whether or not you do the revocable living trust. And the reason is this, is that if you do not have a power of attorney, often, and you start to lose your capacity and you have an inability to make financial decisions, the only alternative that your loved ones have, if you're no longer able to make those decisions, you're no longer able to sign a power of attorney, is oftentimes going through a conservatorship, which is an incredibly, at least in California, it's an incredibly expensive, in terms of legal fees. It's an incredibly demeaning process because you as an individual now are dragged in front of the court, and your loved ones are asking the court to enter an order against you that you don't have the ability to manage your assets, and you don't have the capacity to manage your assets. And for an aging individual, that's, who already feels maybe like they're starting to lose some of their independence, having something like that happen, it can really be a traumatic event. And so in our office, for the last, this office opened up in 1972. We've charged the same thing for a power of attorney since that time. It's $250, and it's the best $250 most folks spend, because what happens is it enables an individual. If I'm the client, it enables me as the principal, and that's the term we use when I create a power of attorney. Me as the principal to name potentially, you, Frank, as the agent for me, and I can now have you act on my behalf to make really critical decisions, including potentially executing a living trust for me. So if I've never done a living trust, you as the agent may have the ability to do that. And oftentimes for individuals and loved ones that are the agents for the parent or loved one, are struggling with trying to get the care of that individual, and oftentimes they want to be able to organize the assets and put the assets in such a fashion where you have a living trust in place. So a power of attorney enables the agent to really take a lot of action that can save a lot of time, a lot of money, a lot of headache down the road. Now, most people, a lot of my clients that walk in, and this is a California-specific thing, have statutory powers of attorney. You can go down to Staples or any office outlet store, any stationery store, and get what's called a statutory power of attorney. And those are effective in a lot of ways. The way in which California drafts its provisions relating to what authority an agent under a power of attorney has, the statutory power of attorney is oftentimes very restricted because in California, in order for an agent to take an action under the power of attorney, it has to be clearly spelled out in the power of attorney. And so what oftentimes folks don't understand is when they have a statutory power of attorney and says, well, my agent has powers A through Z, they think, hey, my agent can do anything on my behalf. But the reality of it is the big banks out there, B of A, Wells Fargo, not to knock those guys, but they tend to operate in their own universe, and what they like to see is very specific language and powers of attorney. If my agent, in my example, you, Frank, would have the ability to go and act on my behalf. So typically what I like to see in our powers of attorney, a statutory power of attorney is about 2 pages long. Our powers of attorney are about 20 pages long because we spell out all those particular items that are so important to be able to act on someone's behalf. And so it's very critical that you have a well-drafted power of attorney that enables your agent to take certain actions.
You know, what you said actually happened recently with a client of mine. I mean, she said she had a power of attorney. I never asked, who did it or anything. And she called me up. She goes, I'm having a problem. I went to the bank and I showed them the power of attorney so I could then start managing my mom's money, and they wouldn't approve it.
Right. Yeah. And unfortunately, that's especially at the big institutions. More of the community banks, you don't have those kinds of issues, but there's a procedure for everything at a B of A, and if it doesn't fit within the rubric of the procedure, oftentimes, even though it's a valid power of attorney, they just simply will choose not to accept it. And oftentimes a client they're forced, their hands are tied. So
yeah,
having a well-drafted power of attorney is a critical thing. And as I said, more often than not, I tell my clients, look, if you do nothing else, if you walk out of here and do nothing else, just do yourself a favor and get a well-drafted power of attorney, because it'll enable you to do so many other things in the future. Now, that being said, you alluded to it at the beginning when you asked this question is, it scares people. Well, it should scare people a little bit because, you are giving the agent a lot of authority. But my thought is, look, that's why you carefully select that individual. You make sure that, hey, this is someone that's close to me that I can count on to make critical decisions for me at critical times. So a lot of care and a lot of thought needs to go into that decision.
And I think there's a misconception about it that I'd like you to clarify, and that is, because I've heard it happen before. I'll deal with a family and I'll say, do you have somebody have power of attorney for your dad? And they'll say, no, we've been trying to do that, and my dad just says, I can make my own decisions. I don't need anybody to do that. And the fact is that he could make his own decisions, but just because you have a power of attorney doesn't mean that power of attorney is going to be making decisions for that person. It's only at a point where they can't make those decisions themselves. So you want to kind of expound upon that?
Sure. Yeah. In California, in most states for that matter, there's generally 2 types of powers of attorney. And this is specifically related to financial powers of attorney. I kind of touched on powers of attorney for healthcare, but specifically with relation to financial powers of attorney, there's really 2 types. One that's what's called an immediately effective power of attorney, meaning when I sign the document and I name you, Frank, as agent, that I now have you now have the authority to despite if I have total capacity the moment I sign that, even in spite of that, you have the ability now to go out and take action under that power of attorney. Now, sometimes that scares individuals, okay? But I'll explain my bias in why I like immediately effective power of attorney. The other type of power of attorney is what's called a springing power of attorney. And so if you think of it springs into effect only when a doctor, or normally what it says, two doctors declare that I'm incapacitated. So only at the time that I don't have the ability to act on for myself, according to doctors or whatever the instrument says. Normally it says two doctors have to declare me, Jamie, incapacitated before you, Frank, have the ability to act on my behalf. So immediately effective and springing. Now the reason I typically now this is just a matter of how folks practice law, okay? And it's an art, not a science, and certainly not everyone has the same documents for every single person. But normally the way I practice law is I encourage my clients to get away from a springing power of attorney, and the reason is this. Believe it or not, and I'm sure it's easy for you to believe, we live in a fairly litigious society, and what happens is that, you, Frank, maybe my son, my loved one, who I say, hey, and you say, you know what, Jamie's really starting to slip here, and I think it's time that we go visit a doctor and get this power of attorney in effect here so I can start making decisions. Jamie's not paying his bills on time, those types of things. And what happens is, I've seen it more than once. Oftentimes, the primary care physician is more than happy to evaluate me and make a determination of whether or not I have capacity. But finding that second doctor to say, hey, Jamie doesn't have capacity, they get very, very nervous about that because they're paranoid that maybe you, Frank, have a sibling that doesn't agree with what you're doing, or there's infighting in the family, and they're afraid that they're going to get sued by somebody by saying that Jamie, that I no longer have capacity. So springing power of attorney, sometimes, I've had it go multiple ways. I've had two doctors sign off, no problem, and now, Frank, you have the ability to act. But I've had it go the other way where I can't find a second doctor, and so your hands are tied at a critical moment sometimes with the springing power of attorney. Whereas the immediately effective power of attorney, it's just like it says, it's the effect of the moment you sign it. So certainly I have this discussion with my clients. Some clients like the safety net of feeling like, hey, you know what, Frank, you can't act until I totally have no ability to do it. But a lot of my clients, I encourage them, hey, if you trust the person now, there's no reason you shouldn't trust them when you're incapacitated. And so a lot of my clients go with an immediately effective, but certainly that's a decision for the client to make.
Yeah. So you mentioned there were two different types of power of attorney. You mentioned you were talking about the financial, and then I guess we'll talk more about the health or medical.
Sure.
So are there actually two different documents for that? And that's part one question. Part two, if so, do you recommend the same person be power of attorney for both, or have different people? What are your thoughts there?
Yeah, so So I was speaking with relation to financial powers of attorney, and there's two kind of flavors of that. But there's also generally two types of powers of attorney. One, as we've been talking about for the last few minutes here, is the financial power of attorney. The second is, and certainly I think is a very, very critical document. Most folks, I really encourage them to have one of these in place too. It's a financial power of attorney for healthcare, or as we call it in California, Advanced Healthcare Directive. And what that document is, it's a medical power of attorney. So I can name you, Frank, as my agent under that document, and you now have the ability, when I can't make my own medical decisions, to act on my behalf. And really it deals with end of life type of decisions. If I'm on, do I want to be on feeding tube? Do I want to have any artificial ventilation? What type of pain relief do I want at the end of my life? And so it deals with those decisions, but it also lets you deal, if you're my agent, Frank, to deal with my day-to-day medical decisions. Should I go see, this doctor, or should I go see that doctor? And so very important document. One difference I would point out between the two documents, the Advanced Healthcare Directive, or what I'm calling is the medical power of attorney, and the power of attorney for finance, is if I'm the principle under the Advanced Healthcare Directive, I can revoke that document at any time, even orally. Meaning, I could say I revoke that document out loud, and then it is revoked. Whereas a power of attorney for finance, it's a little more permanent. If I have to take affirmative action, usually in writing, to revoke that document. Now, the second part of the question was, should there be the same agent for both? That really depends. I mean, most of my clients walk in, and I'll just use a classic example. There's 3 kids. 2 of the kids are great, and one of the kids, the client says, I don't trust them as far as I can throw them. They're a great kid. They just don't have any level of responsibility. Well, that kind of rules out number 3 pretty quickly. And then usually what happens is the client says, you know what, Bobby's very good at managing finances. He's helped me for the last 5-6 years, and I really feel comfortable with him. So I want him to be the person who manages the financial powers of attorney and really makes the decisions related to the economics of the situation. But, you know, my other son over here, he's more of a touchy-feely, emotional type, and I trust him, you know, to make the right decision related to my health care, and I want him. So it just really depends. I encourage my clients to really not just go, geez, you know, it's got to be Bobby to do everything, but really take a hard look at, hey, if you're in a tough situation medically, do you want, you know, Bobby may be great with the finances, but is he going to be great emotionally and being able to handle the situation related to your health care? And sometimes clients say, yeah, he'd be great, and sometimes clients say, you're right, yeah, I shouldn't have him anywhere near that decision, and they put someone else in there. So it really just it depends on what the situation for the particular individual is. But a lot of times it could be the same person, sometimes not, though.
All right. Well, I think we're unfortunately we're out of time, but maybe if there's one thing you just wanted to leave our listeners with, it sounds like to do a power of attorney, just make sure it's done right. Is that right?
Yeah, I would say for sure. And also the other thing I'd leave with just very briefly is when you're seeking out legal advice, you don't, as the consumer, don't typically know the questions to ask. Okay, but you should have an attorney or any professional for that matter who you feel comfortable with and is asking questions that you necessarily haven't even thought of. And so I think that it shouldn't be just a rote, hey, we're going to go in and we're going to do this document and that's the way it is. And you really want to have someone who's listening and asking and extracting questions and trying to get thoughtful answers out of you, as opposed to someone who's just going to produce a document. So,
yeah, great. So, if somebody wanted to get a hold of you, Jamie, or your firm, how would they go about doing that?
Sure. Yeah. So certainly we're on the web. www.gawvanmale.com. That's gawvanmale.com. Or, we're also available via phone, 707-252-9000. So, yeah, certainly happy to help any listeners out there. But more importantly, I'd encourage folks to really ask critical questions of when they're doing these types of documents. So,
Jamie, thanks so much. It was great, great information. I've got to have you back. Lots to talk about. So we'll do it in the future. But again, thank you all for tuning in, and thanks for all your support. Go to iTunes, download our app on your iPhone or Android phone. A lot of different ways. Go to agingboomers.com. A lot of different ways to listen to the show. So thank you all. Be safe out there, and we'll talk to you all soon.